Melanie Yach is a partner at Aird & Burles, frequent speaker and writer on estate matters, recognized as an expert and a leading practitioner in Lexpert and best lawyers in Canada. And we have Stephen Brunswick, who is a partner at Teplitsky Colson and handles many complicated matters, is Harvard-trained mediator, and we welcome both of them. One thing we didn't do is thank the panel, the previous panel. So Kim and her panel, thank you very much for your presentation. So what we have here is Stephen is acting as agent for Wagner Sidlowski and cross-examining Melanie Yach, who is not Melanie Yach. She's novice.
Well, before we start, I just want to say that this is not representative of a cross-examination in the sense that Melanie, who's been sued for negligence, would ordinarily have counsel appointed by Law Pro representing her. And as well, no one can do a cross-examination on a complicated matter in 15 minutes. So it's almost like a hybrid between an examination for discovery and a cross-examination. But the important thing to take away from this is this room is filled with experts on estates and trusts. I'm not. My main focus is asking questions, and usually it takes time to do a warm-up. Melanie is an expert, so it's the questions and the answers that you have to pay attention to, because that's really the takeaway. And I'm not emphasizing law right now. I'm going to emphasize facts, because that's where a case starts, and cases, from my point of view, are fact-driven. And what Jordan didn't tell you is I'm a fact-driven lawyer, because, as I said, facts make the cases. So do my best, and I'm sure Melanie will do hers. So, witness, what's your full name?
Naomi Viss. My friends call me No.
Okay, and are you a member of the Law Society of Ontario?
Yes, I am.
And when were you called to the bar?
In 1997.
And are you currently a member in good standing?
Yes.
And you know you're a defendant in this lawsuit.
Yes.
And have you been in private practice since you're called to the bar?
Yes.
And your firm has also been sued in this lawsuit, correct?
Yes, it has.
And your answers are binding on that law firm, is that so?
Yes.
And your firm, is it a boutique or a general practice?
It's a firm of general practice. We have 30 lawyers. Some of them are practicing corporate law, some real estate. A handful of us are focused on estate planning and estate litigation as well.
And are you a member of any particular practice group in that firm?
I am now a member of the estates group.
And at material times during the currency of this matter, what practice area did you focus on?
So in 2000, I had just made partner at the firm, and my practice from the time I joined the firm until I made partner was more of a mixture of corporate and real estate and estates. I didn't specialize in estates until I made partner, and so in 2001, 2002, 2003.
And when you were working on this matter, did you involve anybody who actually focused on trusts and estates?
Well, I mean, I had the accountant present during most of the meetings with the clients, and so I involved them because my firm doesn't have any tax expertise per se.
Well, did you, aside from the accountant, did you enlist any outside tax expertise?
No.
Were you aware that there were tax issues involved in the formation of this trust?
I was generally aware there were tax issues, but that was Amy's responsibility, not mine.
Well, how did you present yourself to the clients? Did you present yourself as having any particular expertise?
No, I mean, they were generally aware of my general practice. So no, I did not hold myself out as being an expert in estates, if that's your question.
Well, my question is, you say they. I mean, does they include Brad? Like,
Yeah.
Did you explain to Brad that you're not an expert and that you're a general practitioner with some expertise in the area?
Brad was generally aware, I believe, of my limited expertise in estates.
Well, how would you know that he was aware? Did you ask him directly? Did you lay it out for him?
No, but my website clearly set out in 2000 what the nature of my practice was.
Well, did you know how old Brad was at the time?
Yes,
How old was he?
he had just turned 18, I think, a couple of months before.
And did you direct him to your website?
No, but I assumed he's a young kid. He obviously was generally computer literate.
Did you understand he was coming to you for professional advice on the matter of this trust?
Well, the family came to me with a plan to put a trust in place, and I saw myself as being the one who was assisting them in implementing the plan.
Well, when you say the family came to you, who did you meet with?
When are you talking about?
Well, initially, had you met with his parents before you met with Brad? Had you done prior business with them?
Which question are you asking?
Well,
me?
I'd like to know, had you had a previous relationship with Brad's parents?
Yes, I had come to know Jeff and Helen a couple of years before in 1998. They used me to implement or take care of the sale of their house. So that was my first connection with the family, and they came back to me in 2000 and brought Brad to me, and my view was that I was acting for all three.
And had you ever done any work for Brad before?
No.
Had you explained to Brad that you were acting for everybody?
I think it was understood I was acting for everyone.
Well, why do you say it was understood? Did you even have that conversation with Brad?
I don't recall having a specific discussion on that issue, but at all times that I worked on the trust, it was involved all three of the family members.
Well,
And my view was I was acting for all three.
Well, did you think that Brad was entitled to independent representation?
It was open to him at any point to seek out independent legal advice if he wanted it.
And did you tell him that?
No, but it was understood.
Well, why was it understood? Are you inside his brain? And how do you know he understood that?
Well, I mean, he was a very smart 18-year-old, very mature for his age, having been a child actor and been around business issues for a long time. He was headed off to university. He knew enough about lawyers to know he could seek independent legal advice.
Well, how do you know that? How many 18-year-olds do you know now? I mean, it's not like 1940 where they went to work or went to war. We're talking about 18-year-olds who are generally living in their parents' basement.
So at this point, my counsel would be objecting.
Yes.
I just want to point out.
I just want to say I made it clear in the beginning that she would not be unrepresented, but you have to understand that if you're in Melanie's situation, you're going to be peppered with a lot of questions that challenge your expertise, challenge conflict of interest, and other such things. And this is just done to illustrate to you that when you meet clients and do intake, that you have a duty and a responsibility not to just say it was understood or I believed, but to actually lay it out. And I would say that is even more important when you're dealing with an 18-year-old or a young person, right? As opposed to a seasoned businessman who has probably done these things many times before.
And it's unlikely in this situation that my character, not me, my character did not have a clear retainer agreement, engagement letter that each of the three signed
Right.
that addressed the issue of conflicts,
Right.
waived any conflicts.
And I'm, time permitting, I mean, I want to ask about that, but we may as well talk about it as opposed to doing the illustration. See, I would go to the point where I would start asking Melanie if she had notes, if she did a memorandum, if she had an engagement letter, who was present, did she explain it? Did she even suggest to Brad that he have independent accounting advice and independent legal advice? And if she has any record of having done that, because someone in Melanie's
Characters.
situation should be doing all of those things in order not only to practice defensively, which is what we're taught, because when you practice defensively, you're actually protecting the client. I guess the main thing is to protect the client, but it's also important to practice defensively. So I do have a whole bunch of questions I would ask her. A couple I want to ask her if she ever clearly she reported it to insurer, and I would have already asked her if she had an insurance policy that was responsive to this. But I would ask her, and she may not produce it, for a copy of her reporting letter. And I would ask her, did you tell the
My
client
reporting letter to
to
whom?
to Law Pro or your excess carrier?
And then I would look to my lawyer,
And
who
he
would
would-
then take a position one way or the other.
And likely would object. But I am entitled to ask her if she told the client that she was reporting it to her insurance company. And I think she would have an obligation to answer that question, because if it was my situation, I would say to the client, there's a claim against me, or your lawyer's written me a letter, you should get, I'm sending you out for ILA, I'm not going to continue acting on this thing, and I am reporting it to my insurance company. And in the context of discovery, she would have to produce her insurance policy as part of the discovery process. Correct?
Correct.
And we're supposed to ask something about diversity, and so I'm going to ask her that she was running to be managing partner for the firm, yes?
At the time that this lawsuit came to light, yes, I was in the running for managing partner at my law firm.
And how did that turn out for you?
I lost the election, but there was no connection with this lawsuit, if that's what you're inferring, sir.
Well, why do you say that? I mean, did you talk to your partners about the lawsuit?
My partners were generally aware of the lawsuit.
Did they express an opinion to you about your behavior and your conduct?
No, no one said anything.
Well, did anyone ever suggest to you that you weren't, because of this lawsuit, you weren't suitable to be a partner?
No. I lost the election because of the narrow-minded, misogynistic views of my all-male partners.
Well, I put it to you that you lost the election because you were negligent and your partners.
No.
Well,
No.
you were-
I'm not the first nor the last person to be sued in my firm. We've all defended successfully, and I will in this case. I lost the election because of the systemic racism, the systemic chauvinism that is rampant in my law firm.
Well, how realistic is that? I mean, you became a partner in the firm. You said it's an all-male firm. You've been there for a considerable period of time. If you were so concerned about misogynistic behavior or racism or gender bias, why would you stay there?
My client would be, or my lawyer would then be objecting because that's not relevant to the
No,
lawsuit.
it's not relevant, but we were told to bring out this issue of systemic bias in law firms and the things that we're, as members of the Law Society now, are supposed to be addressing. Some of us are, and some of us, like the Wagner firm, which has no women, I might add, are clearly not. But, I mean, we could keep on going with this discussion, but I think the important thing to take away is the potential of conflict, preparation, intake.
Absolutely,
Right.
and addressing potential conflicts of interest. My character should never have acted for all three of the family members. Given the history of working with the parents, my lawyer character should have absolutely insisted that Brad get independent legal advice.
And even if you had a retainer letter signed by an 18-year-old and his parents that waived the potential of conflict without having sent him out for independent advice in relation to that letter, I think that you're falling down on the job. And
The other thing that my engagement letter should have addressed is the limit of my expertise. So I was relying upon the accountant to give the tax advice relating to the trust. And so my engagement letter should have clearly set out the limits of my retainer and made it clear that I was relying upon the accountant for the tax advice.
And to close the circle on that, she should have got a similar letter from the accountant recognizing that he was undertaking those responsibilities, not her character. So that's a snippet.